No gavels.
No insurrectionist spouses.
Just vibes. This is Vibes Only, the podcast that promises to check the vibes of American politics each and every week. And this week, we're going to bring you something a little different. We're going to do a deep dive on the remaining Supreme Court decisions where we expect a ruling in the coming weeks. June marks the end of the Supreme Court term, which is typically when we get the most consequential landmark decisions. We're going to prep you with a basic understanding and some talking points on outstanding cases that we'll be getting between now and the end of the month. Let's get into it. So June is not only Pride Month, happy Pride, but it is also the time of year where the Supreme Court decides what rights we get to keep. And we are currently expecting some major decisions from the Supreme Court between now and the end of the month. So we wanted to take this special episode to dive in to what those decisions might look like with an expert so that you all are prepared as these landmark rulings come down from the Supreme Court.
Yeah, we heard a lot of feedback from the Vibes Only community about the Supreme Court and what we should be looking out for. So we wanted to do one whole Vibes Only specifically dedicated to looking at what's going to be coming out from the Supreme Court with an expert. And that expert is Lisa Graves, who is a legal expert and a researcher, and she has exposed dark money and corruption and is an advocate for fair courts. She's amazing. She actually is also the host of the Courier podcast, Grave Injustice. Get it? Lisa Graves, Grave Injustice.
So today we're going to dive into four major topics that the Supreme Court has yet to rule on this month. The first is abortion. There are two cases before the Supreme Court right now, one involving access to the abortion medication mifepristone, and one that has to do with Idaho's ban on abortion. The second issue is guns. There's a really important case before the Supreme Court about whether domestic abusers are allowed or have a constitutional right to access firearms. The third is the wonkiest, but maybe even the most consequential long-term, and that's about the Chevron doctrine. We're going to talk about what government expertise looks like, where it comes from, and conservatives' effort to roll back government power. And finally, Trump immunity and January 6th. There are several cases in front of the Supreme Court right now that have to do with whether and how Trump and insurrectionists can be held accountable for January 6th. So we're going to dive into each of these topics, understand what the cases are in front of the Supreme Court and what decisions will be impacting us for the next decade.
In perpetuity. Yeah, I feel, we talked about this on the pod already, but we as Americans have been talking about the Supreme Court way more in the last 12 months than we have probably in our entire lives. And we hope with this episode that we're going to equip you with at least some talking points this, ruling season, decision season, so you know what is going on and the implications of the court.
Yeah. I think that a lot of people feel like they're scrambling to understand a Supreme Court ruling after it comes out. So hopefully this will set the stage so that you feel a little bit less anxiety on those decision days. And when you get that push notification or breaking news headline or text from a friend, you already know what the case is about, what the potential outcomes might be, and what we're going to do about it next. We are thrilled to have you here, and we want to learn as much as we can from you about what to expect from the Supreme Court in the coming weeks. So we're going to cover four key topics, and we'll jump right in with one that is probably top of mind for a lot of Vibes Only listeners, which is abortion. There are two key decisions outstanding from the Supreme Court on abortion, one pertaining to the abortion medication mifepristone and one that has to do with Idaho and emergency medicine. Can you just sort of set the stage for us a little bit about these cases and what they're really about, what's at stake?
Yes, these cases are really important. They're the first decisions from this Supreme Court following its terrible and devastating decision in Dobbs 2 years ago. And what's happened is that the court has taken two cases, one out of Texas, a clear case of judge shopping, where a group was created in Amarillo, Texas, to attack the FDA's approval of mifepristone, a safe drug that's been used for more than 2 decades now to help women have safe abortions in combination with another drug. And this case was teed up to a Trump appointee who basically lied by omission during his nomination hearing process by omitting that he had recently written an anti-abortion screed. And so he was confirmed to the bench. And of course, they went right to him to try to destroy access to abortion basically by mail. And that judge issued a terrible ruling in which he cited materials that have since been disavowed. And that decision was approved by an intermediate appellate court that included other Trump appointees who in some ways went even farther. And then it came up to the Supreme Court to rule on. And so in that case, we are anticipating that the right-wing court that includes the people handpicked by Leonard Leo, that court is going to potentially strike down the FDA's approval of that drug. If the court does that, that will throw into doubt a number of other drugs that the FDA has approved over the years because it basically undoes that process. But the real impact would be to really harm the ability of people across the country and millions of people across the country to access that medicine. It's possible that they won't strike it down because the FDA approval process is significant for the corporate world to have it not be unsettled. But given the right-wing anti-abortion focus of this Trump-Leo majority on the court, it's definitely at risk.
You mentioned something that I just want to take a step back and discuss because I think it applies to almost every case we're going to talk about today, which is judge shopping. Can you go into that just one step further and what that is and how it applies to how cases actually get to the Supreme Court?
Yes, it's really extraordinary. What's happened is that over time, there are a number of courts where they create a little courthouse in a particular town. So it's a federal court. It's part of a broader district, but it's the only courthouse in that particular town, in this case, Amarillo, Texas. And so what happened in this case was that a group that didn't even previously exist suddenly creates itself, in that town as if it exists in that town. It's an anti-abortion group. And then they use the fact that they are quote, in that town to file suit for the one judge, the only judge who could hear that case, knowing that he spent his career attacking women's equality, attacking abortion access, and that he is basically tailor-made to rule in their favor. And so it really is gaming the system. It is, not just putting your thumb on the scale of justice. It's basically choosing your ref.
Would love to also just get your comment on the Idaho case that also pertains to abortion access. Basically, my understanding is Idaho passed a ban on abortion that gives very few, if any, exceptions to when a physician would be able to perform an abortion. And at the same time, you have a federal law that says facilities receiving Medicare funds have to offer medically necessary care, even if that would result in the termination of a pregnancy. Basically, like in emergency medicine, that people have a right to have emergency medicine when it's needed, and that's a criterion for receiving Medicare funds. These two laws seem to be in conflict with each other, and that is what drove this to the Supreme Court. What could happen next, and what are the implications for abortion bans nationwide?
Well, that's right. You have a federal law that basically prevents patient dumping, not actually attending to patients' emergency needs. And in this instance, when a woman's health is threatened, even if they're not on the brink of dying at that moment, they're seeking care that could include an emergency abortion. And basically, the state of Idaho is saying, no, our state law only allows these very, very limited exceptions, including, for example, for rape, but only if you've reported it, or if incest, your guardian has reported it, which is also quite absurd, quite frankly. But so their exceptions are very limited. And it's also the case that, this idea that women's health doesn't matter, that unless you're about to die, you can't get medical care at a hospital it's just so extreme.
Right. Just for the Vibes only listener, it's not, these Supreme Court cases are not just a one-off. This web runs deep and it is hyper coordinated. So just to keep that in mind as we're going through these cases, that it's not just we woke up one day and all these things landed on the Supreme Court docket. It's a highly coordinated effort to get them there.
You are absolutely right.
So we have another case in the Supreme Court around guns, Rahimi, which is a decision that they're deciding from the Fifth Circuit. So it's a federal ban on firearm possession by domestic abusers that they may never be applied to any individual. So no matter how violent the individual may be, and no matter how careful the court that issued a restraining order against such individual was in ensuring that they received due process, they're kind of throwing this up in the air. Yeah?
Yeah, the Fifth Circuit basically suggested that unless the person is convicted, they can't have the gun taken away. So a restraining order, which happens, at the beginning of, or at least at the beginning of the case, where someone has come to the police and said this person has beaten me, abused me, threatened me, that restraining order is in the view of James Ho, another Trump-Leo choice for the court. That's not good enough. That's not enough due process. And so the U.S. Supreme Court is considering whether to overturn the ability of states to demand that people who have histories of violence against their partners not have access to guns, because an enormous number of women are killed every single year by their partners by guns. And many women's lives have been saved by the fact that their partners have not had access to guns.
That's right.
And this is a case that was teed up in part by the right-wing groups that oppose common sense gun regulations, but in part because Clarence Thomas, in a case called Bruin, basically rewrote Second Amendment law to demand that only gun laws that would have basically existed in 1789 are constitutional, or maybe 1865. But in essence, that we're stuck in time with gun laws from a period in which guns, were not as deadly as they are now, to compare whether we can have gun laws that protect our lives in 21st century America.
Yeah, I think it's worth it for Vibes Only listeners to just Google who this defendant is. And I think any rational human being in the United States of America would say that this person should not own a firearm.
Yeah. I mean, this is someone who has repeatedly used a gun, shot in the air, or shot, with people around because of, an order at a fast food restaurant, and also obviously his partner, threatening his partner. But that's one of the reasons why some legal commentators think the Supreme Court will not rule in Rahimi's favor, because he's just too bad of a defendant.
Right.
But if that happens, that doesn't mean that we're out of the woods. This court is determined, it seems, to expand the access to guns in America despite the tragedies that have ensued. And so even if they find that this plaintiff is just too extreme for them to get away with going along with, we know that this agenda by the NRA is going to continue forward, aided by these right-wing judges and these right-wing allies of Leonard Leo and Charles Koch.
Right.
We've also seen how long it takes via all of the Trump trials to get a conviction in a criminal trial, right? We literally watched Trump on live TV commit crimes that he's delayed trials for years to avoid accountability. And so the idea to me that someone could pursue a similar strategy and delay their criminal trial and therefore a conviction in order to maintain access to a firearm while that person poses a threat to their partner or someone else or the public at large is terrifying. Like, that's obviously that's such a broken system to have essentially a technicality that's going to enable someone who is universally understood to be a threat to continue to possess a firearm.
Yeah, it's so extreme. I really appreciate how you put that, because the right to a speedy trial in the Constitution is a defendant's right. But if the defendant doesn't want a speedy trial, they can try to drag things out, as we've seen. And if you need that conviction in order to take away someone's access to a gun, you just have day after day, week after week, perhaps year after year of risk that person will kill the people that are pursuing him for hurting them in the first place.
Horrifying. We will definitely be watching this case. And I did just want to note there's another case relating to guns in front of the Supreme Court still that has to do with bump stocks, which are like the little thing that you can, an adjustment that you can make to a gun to basically turn it into a machine gun.
Why does any average individual need that on their gun?
Yeah, no, it is. It increases the death capacity substantially. And, there's already a lot of damage by, purely semi-automatic guns that fire pretty rapidly, but having a bump stock increases lethality just by a dramatic proportion. And the fact that the court has taken that case again is a sign of how out of control this court is. This court only took 60 cases this year. All of its cases are discretionary. It receives more than 8,000 petitions for cases, but it is handpicking cases like this in order to destroy our rights, and I think destroy our public safety by catering to the far right, catering to the right-wing agenda.
There's another set of cases that the court has chosen to take on very strategically that could undermine how the government functions for decades to come. And those are the cases relating to Chevron deference. This is where things are going to get a little wonky. So for our vibes-only listeners, we're going to keep it as conversational and accessible as humanly possible.
Okay.
Tell us first at the very top, we'll start, like, what is Chevron deference?
Yes.
Why does that matter to the everyday person?
Chevron deference is based on a case that came out about 40 years ago. And the reason it matters is that we have a whole host of regulations that protect our health in the workplace, the safety of our food, clean water, and more. And those are all rules that are adopted by agencies based on their expertise in water law or how chemicals get into the air in your workplace or what have you. So courts are required to defer to agency expertise when the agency has authority over that area of law. And what's happened is that there's an effort to reverse that precedent to allow basically endless litigation about the rules that keep us safe.
So deference, meaning the courts are going to defer to agency experts, as particularly on like matters of science. Chevron being the case that it actually came from equals Chevron deference.
Yes, that was excellent vibes only summary. Thank you so much. Seriously.
We got to make it stick. Yeah, the food example that you raised sticks out to me. I have talked about this in respect to like clean air and clean water. If I read the back, like the nutrition facts on a snack at the grocery store, I cannot understand literally half of the words that are in the ingredient list. Like if you look at some kind of processed food, like we need experts to be telling us what is safe to put in food and what is not. I do not want Marjorie Taylor Greene and Lauren Boebert in Congress making that decision. I do not trust them to know what xanthan gum, that's the only one coming to mind, or like whatever, what these things are. So there are two cases, Loper, Bright Enterprises versus Raimondo, and I believe Relentless versus Department of Commerce. There are these two cases. What could happen with Chevron deference? What could change as a result of rulings in the next few weeks?
Yeah, I mean, it would throw into chaos. Rules about food safety, workplace safety, the whole 9 yards, just as you point out, because the court is poised with these right-wing appointees of Leonard Leo, with the help of Charles Koch, by Donald Trump, to destroy that precedent, to reverse that precedent and say it's open season on these regulations. Any company, any front group or whatever can come into court and basically try to undo regulations and claim that we don't think it's reasonable and you shouldn't defer to the agency's expertise, and basically tie up those regulations for years to come. That includes old regulations as well as new regulations. So it could affect climate and so much more. So it would be a disaster for the working of our federal government to help keep us safe, to basically have a situation in which only if Congress, for instance, Marjorie Taylor Greene, agreed on some new regulation of climate could the EPA act within its reasonable authority over environmental protection or over carbon or the like. And so it would throw everything into chaos. It's not just about the fishermen who are the plaintiffs in that case, whose litigators are being fueled by Charles Koch, whose agenda has been advanced by Leonard Leo. It's about basically trying to handcuff the ability of the federal government to keep us safe from these big corporations and their practices or products that are unsafe or that could harm us.
It makes me sick to my stomach to think that big oil could come in and say, actually, all of these EPA protections or all of these clean air protections, they don't matter because our agenda is more important and we want to push our product onto the American citizens. And that's the reality of what could happen.
Yeah, I mean, it is the role of big oil in this, and Coke in particular, just cannot be overstated, because when you look at what their response was to the decision in EPA, West Virginia versus EPA, their lawyers basically touted how great this was, that now there was going to be a win against regulations that affect major questions.
Right.
Now it's any question, not just major questions, they could undo, they win this case.
And what do you think the odds are of a worst case scenario in this rule, like of a worst case ruling, are right now in these cases?
I think they probably have at least 5 votes to overturn Chevron, because that's how they have constructed the court to, one of the things they've constructed the court to accomplish. It's possible that they could try to sort of half undo it in a sort of John Roberts slow walk toward their destination. But I think that that's the destination that they're going for. And that's the destination that Koch wants. And that's the destination that the sort of right-wing Federal Society, lawyers, Phil Hamburger, this sort of fringe theories that have now become dominant. That's what they want. And so I think because this court is feeling so arrogant and emboldened despite the corruption crisis, I don't think it's going to hesitate to do what it wants to do, which is overturn these key precedents of the 20th century.
Cool.
Yeah, that's not a good vibe. That's not a good vibe. It's not a good vibe. I'm so sorry.
No, we need the truth. We need the truth.
I know we do.
For our listeners who maybe you were familiar with Chevron deference before listening today, maybe you were not. That is in a different area of law, the equivalent of Dobbs, of Dobbs overturning Roe v. Wade. That is a complete reversal of how the government has worked, how law has interpreted what the role of federal agencies is.
And experts,
of course. And so while it's not going to get the type of media attention, it will have the same gravity in its impact. And so we need more people to be paying attention to this, even though it's wonky.
Yeah, I really appreciate it. I'm so excited for the Vibes Only audience to have a chance to talk with you here about these issues, because as much as there's a smile in my voice to have the chance to talk about them, that's only because we have to know about them in order to know what's coming, and also to not be defeated by them.
Right.
Because this is a snapshot in time, and it just builds the case for why we need court reform, why we need to, expand our ability to protect ourselves from these big corporations that their interest is the bottom line, not necessarily our safety, and also these sort of right-wing billionaires who really want to rewrite America back to the robber baron era of the 1900s. It's crazy.
It's crazy.
But we don't have to take it. I think if we see these decisions and they come out toward this right-wing agenda, I think it just needs to be fuel for us to come together to say, no, this is not okay with us. This is not okay in 2024 in America. And we want to have, a better America, a better future where we can thrive.
Yeah, that's right. We're going to talk about one more case that I think the Vibes Only community is most familiar with, which is the Trump immunity case, where Trump claims that he has absolute immunity. Can we just riff on that a little bit, talk about it a little bit? Because in the 2024 era, it's on top of everyone's mind, and Trump is this existential threat to the country.
Yeah, I mean, absolute immunity is ridiculous. That's what kings have. We are not in a kingdom. We're in a democracy, and our Constitution does not mention privilege for the president at all, let alone absolute immunity, any sort of immunity. And so Trump's claim, it is an existential threat, because basically, as they said at oral argument, they believe that the president could order the assassination of people he doesn't like, his political rivals, and that would be immune from prosecution unless Congress impeached him, a Congress that's beholden to him, as we saw, where we got a majority for impeachment of Trump after January 6th, but not to the supermajority needed in the Constitution, that he could do whatever he wants.
Unhinged.
And that is the most dangerous idea I could even think of, this man being able to do whatever he wants without any risk of criminal prosecution. By taking the case, they've really already put their thumb on the scale in favor of Donald Trump by making it almost impossible for that case to go to trial and be resolved before the election. And yet, when the Colorado case came up about Trump being removed from the ballot, boy, did they act fast, right? So they can act fast when they want to, but right now they're dragging their feet in order to help him, and that's what that right-wing majority of the court is doing. Donald Trump is getting what he wanted out of that court by them delaying this trial.
There was a second case that has a relationship to the Trump immunity case, and that's Fisher versus United States. Fisher being one of the insurrectionists on January 6th, which has taken his case all the way up to the Supreme Court. And it's a case about whether a specific criminal charge that was used against the January 6th insurrectionists is valid. There was a specific law that the government used to prosecute these people that has to do with obstruction of an official proceeding is my understanding of it. And the Supreme Court is going to make a decision about whether that was a valid charge to use. What can you tell us about the significance and potential outcomes of that case?
Again, this is where the Supreme Court has reached out to take a case that it didn't have to take in order to, weigh in on this particular issue. And I think this goes to a broader question of what the legal agenda of this court. So, you have a statute like that says, obstructing an official proceeding is a crime. The language is plain. Obstructing an official proceeding is a crime, just to paraphrase. And they were certainly obstructing an official proceeding. They were trying to stop the electoral count from happening. They were trying to stop the legitimate vote of the American people through the proxy of the Electoral College from being counted. That's what the whole purpose was. That's why Trump said, go fight. You're going to lose this country if we don't fight, et cetera. Now, what this court wants to do potentially is say, well, but if you look at the original intent, the particular, intent of the drafter of that law, it was narrower. And that's what they've been doing all over the place, is try to claim that the law on its surface is not our law. The real law is some subterranean, what some person thought, at the time they passed it. And original intent is part of this originalism sort of doctrine that is not a doctrine, but is a concoction that has been grossly distorting our law. And I'll just give you one example. So when the Civil Rights Act was passed in 1964, some of these right-wing legislators put a poison pill in it by adding women to the Civil Rights Act protection because they thought that would kill that law, that it would not pass if women got equal protection of the law. But it passed. So now are we governed by the intent of the people who added women, that they didn't want women to have access to civil rights? Or are we guided by the actual law that passed? Of course, we should be guided by the law that passed. The same with the Second Amendment or the Fourth Amendment or the Fifth Amendment. We should be guided by the law, the language of that law, not stuck in time to what one person or five people thought when they supported a particular bill back in 1789 or 1920 or what have you. The law has to be something that we are governed by in the year we live in. And what does that law mean? Clearly, it applies to these protesters who weren't just protesters. They were actually not engaged in, nonviolent disobedience. They were attempting to subvert our election and violently disrupt that electoral count. So we'll see what they do. But it's, again, disturbing that the court has gotten involved in this and that those arguments were accepted as legitimate.
It's a lot. It's overwhelming. It's kind of ungrounding to hear all of these different powers that be that are manipulating us as Americans. What can we do? If you're an average American, what can you do full stop?
Well, first of all, I would say hope is an act of defiance. Hope is an act of resistance. We cannot give up hope that we can change this. If we do, the forces of darkness basically win. The people who are trying to regress our society win. So the first thing is to be like, anger is a legitimate, righteous anger is a legitimate response to taking away our rights. But then it's like, well, these are moral issues. These are our rights. This is our democracy. And if it's a moral issue, you don't give up just because you lose this battle or you lose this case. We have to have, strategic patience. We have to have resilience. And for an ordinary person who's like, this court is driving me crazy. I am with you. This court is driving us, nuts because it's so extreme, but it doesn't have to be that way. It doesn't have to be that way. And the way that we can change it is through registering to vote, getting our friends to vote, voting, and then voting in the next election, to build the society that we want, a progressive society, not a regressive society.
Yeah.
Absolutely.
And share this podcast episode because we learned
share
a lot.
this podcast episode and subscribe to Vibes Only.
Yes, Lisa.
Yeah, absolutely. I'm not just pandering, really. I'm saying it's so important what you're doing. And I really appreciate your breaking it down because some of the stuff, they count on it being so obscure that people won't think that they have a role or they have an opinion in it or that they can't change it or they can't understand it. But it's actually pretty clear. What we have is an authoritarian movement that is fueled by some of the richest guys on the planet, including Leonard Leo now with his, $1 billion trust fund, trying to enact their narrow view of the world on us, impose their views on us as a matter of law. And we outnumber them. Right. And if we come out, if we vote, if we continue to vote and talk to our friends and neighbors about what we want in our society, we can change this.
Absolutely. They make it purposely elusive so we don't engage, but as many conversations as we can have and just normalizing talking about it, we can go so far.
Absolutely.
Well, that was illuminating. Lisa's definitely going to come back because there was a lot of things she talked about, whether it be Leonard Leo, Project 2025, Heritage Foundation, that I just want the Vibes Only community to have more insight on because it is a hyper-strategic conservative network that has gotten us here. But that was super helpful for me to hear as someone who is intimidated by the Supreme Court to feel more grounded in what's going on.
Yeah, we're going to be getting some Obviously, really intense decisions over the next couple of weeks, and several of these cases could have pretty catastrophic impacts. But it's important for people to remember that this is about the long game. And any bad decision that comes down that restricts our rights or rolls back progress is something that we're going to have to work really hard towards undoing in the future. And that starts with the November election and not letting the court swing any further to the right than it already is.
Period. That's all the vibes for this week. We hope you learned something new and feel more empowered to talk to your friends and family about the Supreme Court. If you liked this episode, please share it on social media with your friends and family. We'll be back again next week to check the vibes. See you then.
Vibes Only is produced by Devin Maroney, with support from Courier's Kyle Tharp, RC DeMezzo, and Daniel Strasburger. Tara McGowan is founder and publisher of Courier.